Chapter 4 Quick Revision. Guys, don't miss this chapter because it is very small chapter and short in every attempt 5 marks questions was coming from this chapter, so don't miss this chapter. First, quasi-judicial authority is an administrative body or agency that has been granted the power to make decisions that affect the legal rights, duties or privileges of the individual or entities. Quasi-judicial authorities are distinct from the judicial authorities, which are courts that have the power to hear and determine legal disputes. Quasi-judicial authorities are established by the law and are typically created to regulate specific industries or sectors such as securities, telecommunication, real estate. For securities, SEBI; for telecommunication, TRAI; for real estate, RERA. Quasi-judicial authorities are required to follow the principles of natural justice. Parties before quasi-judicial authority have the right to legal representation and to appeal against the decision of the authorities to higher courts or tribunals. Next, procedure for appearance. The procedure for appearing before these authorities may vary depending on the specific authority and the nature of the legal matter. However, some general guidelines for appearing before regulatory and quasi-judicial authorities are followed. So, general guidelines for appearance means these 5 points. First, preparation of the case, appointment of legal counsel, compliance with the procedural rules, conduct during the proceedings, compliance with the orders. Means it says the flow. First, preparation of the case. After case has been prepared, appoint the lawyer or advocate. Next, comply with the rules and conduct during the proceedings, hearings. Last, order. Next, right to legal representation. The right to legal representation is also recognized in the international human rights law, including international on civil and political rights. The right to legal representation is a fundamental right that is recognized in most legal systems around the world. In many legal systems, the right to legal representation is enshrined in law and guaranteed by the Constitution. In some cases, the right to legal representation may be limited or restricted only in some cases. However, even in such cases, parties may still be entitled to a fair hearing and other procedural safeguards. The right to legal representation is a fundamental right that is essential for ensuring fair and just legal proceedings that helps to balance the power dynamic between the parties, protects the rights and interests of the individuals and promotes the rule of law. So, for this topic, we can write in conclusion the 3 lines enough. Next, appearance under Companies Act. So, first, some key provisions related to appearance under Companies Act 2013 are appearance before ROC, appearance before NCLT, appearance before SFIO, appearance before SEBI. So, ROC, it will look after all the regulatory authority and compliance matters. Next, NCLT is a quasi-judicial body and SFI is a specialized investigating agency. We will read more about in CMEDD also about this. And next, SEBI. SEBI is a regulatory authority related to securities market. So, 4. ROC, NCLT, SFIO, SEBI. ROC, NCLT, SFIO, SEBI. Next, appearance under TRAI. Appearance before the TRAI. First, in tariff related matter. Next, consumer. Next, licensing. Tariff, consumer, licensing. Tariff, consumer, licensing. Tariff, consumer, licensing. And last is disputes and grievances. Next, appearances under the SEBI. Appearance before SEBI in compliance related. So, appearance is full of appearances under SEBI is full of compliance. So, first point also compliance related matter. Next, investigation. Next, adjudication process and SEBI in appeals will go to first SEBI to SAT to Supreme Court. So, first, compliance, investigation, adjudication and appeal. Compliance, investigation, adjudication, appeal. Appearance under Competition Act. So, first, appearance before CCI in complaint and information matter. If company is entering into anti-competitive agreements, so any people getting affected may complain. So, first dealing with those complaints. So, complaint and information matter. Next, combination matters. Next, in appeal and review matters means if any person agreed by the CCA can go to the appeal to NCLAT. Next, leniency matters. At last, only in Competition Act, CS as an expert, this extra point will come. Only in Competition Act, 5th point, CS as an expert. So, first, complaint and information matter, combination matter, appeal and review matters, leniency matters, last, CS as an expert. Next, appearance under RERA. In RERA, CS holding the certificate of practice can represent a person before real estate appellate tribunal and represent a person before adjudicating officer. So, before adjudicating officer, before tribunal and before the regulatory authority, in three places also CS can be represented by a person. Appearances under RERA in complaint. First, complaint matter, registration matter, complaint registration. Majorly immovable property means registration. So, keep in mind RERA registration. First, complaint. Next, registration. Next, dispute. There are many disputes relating to the registration or immovable property. So, dispute resolution. At last, appeal. First, complaint, registration, dispute resolution. Last, appeal. Next, appearance under RBI. First, there are some key consideration for the professional appearing under RBI. RBI will not allow everyone to go against or go to the RBI. So, there are some key consideration. First, understand the provision. Next, prepare relevant information. Consult with the internal stakeholder. Engage legal counsel if necessary. Next, prepare for the appearance. Maintain professionalism. Comply with the RBI's instruction. Facilitate communication. Take notes and maintain the records. Last, follow up and compliance. So, first, understand the provision. On basis of what you have understood, prepare the relevant information. Next, consult with the internal stakeholders. Next, engage a legal counsel if necessary. Prepare for the appearance. Next, maintain the professionalism. In appearance, you have to show the professionalism. So, maintain professionalism. Next, comply with the RBI instruction. Facilitate the communication. Take notes and maintain records. Follow up and compliance. Next, appearance before the ED. ED comes only if economics crime related or any fugitive fugitive offender under FEMA and money laundering. If that related matters, appearances will go under ED. Next, appearance before stock exchanges, insider trading, UPSC related that. Appearance before IPR authority. So, copyright, patents, geographical indication, intellectual property and that all. That IPR authority. Next, appellate authorities under Companies Act. First, NCLT. If from order of NCLT not satisfied, NCLAT. Next, Supreme Court. Next, here ends. This is a separate segment. RD. From ROC will go to RD. So, first one was from NCLT to NCLAT. From NCLAT to Supreme Court. From NCL to NCLAT in 45 days. From NCLAT to Supreme Court 60 days. And both NCLAT and Supreme Court both will allow the extension of time if sufficient cause is there. Next, from ROC will go to RD. And last, Company Law Board. Now it is NCLT. Now don't read Company Law Board. Instead you have to write NCLT. Next, appellate authorities under SEBI. First, appeal to SAT, Securities Appellate Tribunal. In 45 days we have to file from the order of SEBI. Next, procedure for filing an appeal with the SAT. Filing of appeal, service of the notice, hearing, decision. Filing of appeal within 45 days and service of notice so that opportunity of being heard will be given, and hearing to seek the clarification and further evidence, and decision will be passed. And SAT should solve the case within 6 months. Appellate authorities under Income Tax Act. First, Commissioner of Income Tax. Commissioner of Income Tax. Next, Income Tax Appellate Tribunal. First is Commissioner. Second, Income Tax Appellate Tribunal. And last, High Court, Supreme Court. First, Commissioner. Next, Income Tax Appellate Tribunal. First, Commissioner. Next, Tribunal. So, 3 also covered. See, first, Commissioner. Next, Tribunal. Next, Courts, High Court and Supreme Court. Next, Appellate authorities under Competition Act. NCLAT, High Court and Supreme Court. From CCI will go to NCLAT, and NCLAT to High Court, and High Court to Supreme Court. And at last, SS still matter of for CIRP. In this last one para enough, this case study highlights the challenges involved in CIRP process and underscores the importance of a transparent and efficient resolution process that enables the resolution of distressed assets while protecting the interest of different stakeholders. It also highlights the need for a clear and predictable legal framework for dealing with the distressed assets and importance of balancing the interest of different stakeholders in the resolution process. First, their resolution plan was not approved. Later in the Supreme Court it was approved. That was happened in this case. Done. We are done with chapter